You knew that he had been to the gun range with his mom the weekend prior.
Yes.
You knew at a minimum that he had access to a firearm the weekend before because he went to the gun range.
I knew that he had been to a gun range and had used a firearm at a gun range, yes.
You did not ask him on November 30th of 2021 if he had access to a firearm.
I did not.
You had no reason to look into whether or not he had access to a firearm. Would you agree with that? Based on the information that you had.
It's easy to go in hindsight on a lot of things. Based on what my concerns were, I was concerned about student well-being.
And again, you said it's easy to go in hindsight. So we know what happened within a couple hours of this meeting.
Sure.
We all in this courtroom know what happened. It's easy for us to look back and say that different decisions could have been made, right?
I made the decisions I made based on the information I had
At the time.
at the time.
You don't have the benefit of hindsight at 10:40 or 10:50 a.m. on November 30th of 2021. Is that fair?
I had 90 minutes of information.
You suggested that his parents find a therapist for him to talk to or evaluate him.
I did.
You have had experience with parents who have refused to provide mental health treatment to their child. Is that accurate? Do you recall that?
Off the top of my head, I'm not recalling a specific instance of that.
If it occurred, do you remember testifying previously about that?
I don't know.
Okay. Would reviewing your testimony on that help to refresh your recollection?
If we want to bring it up, sure.
May I approach, Your Honor?
Sure.
Thank you.
If you would like to read the highlighted portions, Mr. Hopkins, thank you.
You can just read that to yourself and let us know if it refreshes your recollection. All right?
Thank you, Your Honor.
Yeah, so I had asked, like, if it's occurred, and I say it's not overly common, but I'm sure it does happen. But I'm giving a for instance of what we would do in that type of situation if it were to happen.
May I approach, Your Honor?
Sure.
Thank you. So reviewing, based on what you just said, reviewing the transcript has helped to refresh your recollection.
Well, what I'm stating in the transcript is in a situation where that could happen, that what we would do is involve CPS and make sure that the student is receiving ordinary care.
In fact, the question was,
You told the jury what CPS is.
Child Protective Services would be involved if that situation were to occur.
in fact, the question was, thank you, okay. Had you ever dealt with a kid at school who you felt needed psychiatric care and yet the parents didn't provide it in some fashion or another? Your answer was yes, that had occurred.
And then I go on to explain what would happen in that type of situation.
Right. You said it's not overly common. It does happen. If it did happen, this is what we would do. Correct?
Correct.
And I know I've asked this a couple of times, but you didn't have any reason to believe on November 30th of 2021 that James Crumbley or his wife were not going to follow through and obtain a therapist for their child to talk to.
I didn't have enough time to know if that would happen or not. Given our context of our conversation, no, I didn't have reason to believe that at that time.
If you recall, the meeting with Mr. Crumbley and his wife and their son concluded at approximately 10:50 in the morning.
That sounds about right, yes.
Their son left the room first, if you recall, and went back to class.
Yes.
The shooting occurred at began at approximately 12:51 p.m. that day.
Okay.
After you heard that there was a shooter at the school, you did not immediately suspect that it was Mr. Crumbley's son, if you remember.
I did not.
In fact, you didn't suspect that it was Mr. Crumbley's son until you looked into his attendance after the shooting.
Correct.
This is also after Mr. Crumbley's son had already been arrested.
Quite a bit after this.
I'm going to talk about just a few things. Just go back to your direct testimony with the prosecutor. Said that calling a parent in is a high level of concern.
Yes.
And that could be a concern for appropriate behavior.
It could be, yes.
It could be a concern for the student's well-being.
It could be.
It could be a concern that the student needs immediate care or help.
Yes.
It could be for any number of reasons. A high level of concern is dependent on the situation. Is that fair?
Yes, I would agree.
You're concerned with going to Mr. Crumbley's son's class on November 30th of 2021 is you specifically mentioned that you went because it doesn't basically raise concern or red flags if a counselor goes down to get a student out of class.
Yes, that is true. And I had very little information at that point as to what was going on. So I wanted to make sure to do it. And I knew that the dean wanted me involved in a conversation. So I knew that student support was at least a potential plan at that point.
When you were discussing, you said that you told Mr. Crumbley's son while you were meeting with him before his parents got there that you wanted his parents to get him help. Do you remember discussing that with the prosecution?
I do.
At that time, Mr. Crumbley's son didn't say, "Thank goodness, I've been begging my parents for help and they haven't given it to me."
I'm not sure many students would.
He didn't say, "I'm glad you're going to ask them because I've asked them and they didn't listen."
He did not say that, no.
He didn't say, I really need this and I'm really glad that you're doing this for me."
He did not.
He didn't say any of that.
No, which also would not be, it's not uncommon for students to not have a big response to something like that.
If he had said any of those things, obviously your reaction would be different when Mr. Crumbley and his wife got to the school.
It would be different information that I did not have, yes.
And when Mr. Crumbley and his wife were at the school, they also didn't say anything about, or Mr. Crumbley didn't say anything specifically about, wow, son, you really did need some help. You've been asking me for it, right?
No.
The discussion was simply looking at the math assignment, the modified math assignment, and then Mr. Crumbley expressing to his son, you know you have people to talk to, right?
That was a piece of it over the 10 minutes, yes.
That they've talked. Mr. Crumbley and his son have
Yep,
spoken.
he did say that they talked.
When discussing the impact of Mr. Crumbley's son's friend leaving, you don't know that Mr. Crumbley's son had ever expressed how significant that impact was on him. Is that fair? Until sitting in your office.
I had very little context, even when he was in my office, over what that was. All I knew is that a friend had left recently, had moved, and that was hard.
You indicated on your direct testimony with Mr. Keese that Mr. Crumbley mentioned you have people you can talk to, we talk, and then mentioned something, your testimony was that his son mentioned something about a journal, or I'm sorry, that Mr. Crumbley mentioned something about a journal.
Mr. Crumbley's statement to my recollection was, you have your counselor, you have your journal, we talk.
Mr. Crumbley didn't say, your journal, you know, the one that's in your backpack.
No.
He didn't say the one that you always keep with you.
No.
He didn't say a color.
No.
He didn't describe it at all.
No.
So, to your knowledge, based on that conversation, you can't say that Mr. Crumbley's son knew what his son's journal would look like if he had a journal. Based on that conversation.
No, I had no knowledge beyond that there was an existence of some sort of journal.
One moment, Your Honor.
Sure.
Mr. Hopkins, you made decisions on November 30th of 2021 based on your education, your training, and your experience, correct?
That was a piece of it.
Also based on the information that you had in front of you.
That was a majority of it.
which included 4 emails from teachers in approximately 2 months regarding Mr. Crumbley's son.
That was a part of it, yes.
Concerns that those teachers had raised,
Yes, that was a part of it.
much of which you did not share with Mr. Crumbley prior to that November 30th meeting. Is that fair?
Correct. It was shared during the meeting.
Based on all of these things, you did not believe that Mr. Crumbley's son was an immediate danger to himself,
I did not believe that, no.
nor did you believe that he was a danger to anyone else.
Based on the information I had, no.
I have no further questions.
Read that.
Thank you. Mr. Hopkins, it appears that information and context would be important to you in these kinds of meetings.
Yes, it would.
Okay. Now, did James Crumbley tell you that November 30th wasn't the first time that his son asked for help?
No.
Did James Crumbley tell you that his son asked for help in April of 2021?
No.
Did James Crumbley tell you that, despite that, never once was an appointment with a medical health provider set up?
No.
Did James Crumbley ever tell you that as early as June of 2021, his son had obtained his own firearm?
No.
Did James Crumbley tell you that his son had been begging for a 9mm firearm?
No.
Did James Crumbley tell you that his son actually sent him a screenshot of a 9mm for sale a few weeks before the meeting?
No.
Did James Crumbley tell you that his son actually obtained a 9mm just 4 days before this meeting?
No.
Did James Crumbley tell you that the 9mm he obtained looked identical to the 9mm that he drew right here on this picture?
No.
Did James Crumbley tell you that he worked for DoorDash, he hadn't begun work that day, and he could have taken his son home?
No.
Did he tell you that when his son was talking about his friend leaving, it was actually his only friend?
No.
So you took what you learned from the defendant's son, you described those losses he felt as significant,
I did.
and that's without knowing all that information?
Yes.
You mentioned that you would hope that a decision about a student would be made by a team.
I did.
Who's on the team?
The student, the parents, and any caring adult at the school.
And did either James or Jennifer Crumbley share any information with you?
I did not.
Had they of, what would you have done?
Objection, Your Honor. Speculation.
She asked the same question on cross.
Did you ask that question?
She asked, what would you have done? Talking about calling CPS and such.
I no, actually, that was related to if they had.
Well, she asked if they had not obtained treatment for their son
Yes.
by the following day or within 48 hours.
If they had refused, actually, if they had refused to obtain mental health treatment, what would he have done? Not,
I'll rephrase, Judge, that's fine. Mr. Hopkins, you testified earlier that your plan was to call Child Protective Services within 48 hours?
Yes,
And that's based upon just the information that you learned from the defendant's son?
it is.
Would this meeting have ended differently had you known all the other information that we just went through?
objection, Your Honor. Speculation.
I think it does call for speculation.
I believe he can offer a definitive answer here, Judge.
A definitive answer about what would have happened if they had not contacted a therapist. Is that what you mean?
No, Your Honor. He's asking about a definitive answer for what Mr. Hopkins would have done if there had been additional information. And Your Honor, can we approach? Can we approach, please?
Okay, can you turn off the mic? Possibly.
Thank you, Mr. Hopkins. You were asked on cross-examination that you didn't ask the shooter on November 30th if he had access to a gun. Do you remember that?
I do.
And your response was what?
I did not.
Okay, and did you have reason to ask him about that?
At that time, I didn't feel I did.
And you were asked about the shooter's recitation of what happened at the shooting range with his mother.
Are you stating I asked that?
No, you were asked that.
Oh, by Cross.
Okay, so you learned on November the 29th and November the 30th that the defendant's son went to a shooting range with his mother that prior weekend.
I did.
Did James Crumbley tell you that the shooter actually shot his new gun?
No.